What a lovely sunny day. Good afternoon, everyone. How are you today? Just so. I'm fine. What else? Fantastic. Rather good. Pretty good. You know, this is a rather good word to replace very. A pretty good person is not better than is better than a very good person. Okay? This is better. It's an adjective. No, it's an adverb. It's an adverb. Okay. Last week, we talked about some basic knowledge about the case study of WTO law, and I briefly introduced some cases. As you can see, we will number them. Number 1, number 2, number 3, number 4, number 5, number 6. Now let's do the draw. I'll invite the 6 team leaders up here and make a draw. Please, up come. Okay, you can draw. It's yours. There is no number 9. Okay? Okay, settled? Everybody knows your number, okay? Good. I was wondering which team has a member of 5 students? Have a number of 5 students? Your team? Which team has 5 members? No? Then let it be. Okay. Let's continue with our class. Okay. Now let's resume from slide number 4. Slide number 4. Slide number 4. I will give you several questions, okay? Imagine there is an arbitration, international commercial arbitration, ICA, okay? Happened between 2 private parties. There is this dispute, okay? And there is a WTO case. What's the difference between these 2 cases? Can you guess? A WTO case and an ICA case. The difference, number 1, the WTO case belongs to a dispute of public nature. Yes or no? Yes, good. And this is a private nature. Good. What else? Another rather important point is the result of the arbitration in ICA is only binding upon the 2 parties. Yes? Well, in the WTO dispute settlement, the result of a particular case is not only binding on the two disputants, I mean the complainant and the respondent. It also has a binding force on other countries. Why? Why? Because for example, in a certain dispute in WTO, a third party that is not a party to the dispute can also declare that they have an interest in the case. There is a third party. The disputants, and there are third parties. Third parties, besides to the two disputants. Look here, a third group of countries can declare that they have an interest in the case and enjoy some rights. Therefore, multilateral dispute settlement mechanism involves public interests rather than merely conflicts between the two parties to the dispute. Multilateral dispute settlement system. Multilateral. You know the word? Okay, good. Multilateral dispute settlement system has a public nature. It involves public interests. Okay. That's one rather important thing you need to know. Let's go on to look at the next paragraph. Okay. Have you ever heard of the Uruguay round of trade negotiations? Uruguay. Yeah, good. Very good. Uruguay round of trade negotiations or trade talks. It's a round of talks or negotiations, not just one time, okay? Several times in this round. And it was concluded in 1994, following 7 rounds of trade talks, which means there are seven rounds of trade talks preceding the Uruguay round. Means before the Uruguay round negotiations, there are 7 rounds of talks. And in this round of negotiations, in this round of trade negotiations, it was decided to establish an organization. And the name of the organization is at the end of this round of trade negotiation, it was decided to establish an organization whose name is WTO. to put it another way, WTO is the result of the Uruguay round of trade negotiations. Okay? And under the WTO agreement, there are, how many annexes are there? How many? 4, right? 4 annexes. The most important one regarding procedural issues is annex. Which annex? Regarding procedural issues, the most important annex regarding the procedural issues is annex procedural. As opposed to substantive. And institutional. Now, in the WTO system, there are 3 categories of rules. They are procedural rules, substantive rules, and institutional rules. In Chinese, they are called 程序性规则、实体性规则、组织性规则。Okay. And let's come back to my question. The most important annex relating to procedural rules is Annex 1, Annex 2, Annex 3. Which one? Annex 2, good. And the name of Annex 2 is? Good. DSU. And the full name of the DSU is Dispute Settlement Understanding. Good. And the full name of the Dispute Settlement Understanding is? The longest one. Look here. Let's try to locate the answer here. We don't have the answer here. Okay. Doesn't matter. The full name of the dispute settlement understanding is, the name is a little bit longer. I don't think I can remember it for myself. Here, I got it. You know? Yeah, read it out loud for everybody.
Understanding on rules and procedures governing the settlement of disputes.
Good. Again.
Understanding on rules and procedures governing the settlement of disputes.
Okay, I think I remembered it. Understanding on the rules and procedures of dispute settlement, yes or no? Understanding on the rules and procedures governing the dispute, the settlement of disputes. Okay. It's in the teaching materials. Good. Let's go on. Let's move on to next point. Okay. If you are one of the two disputants, would you like the dispute to be resolved promptly or slowly? Quickly or slowly? Yes. Quickly, okay? Quickly. Why? It's a matter of course. No why. It's a matter of course. What does a matter of course mean? Of course. I bet everybody knows. Of course. What about a matter of course? 理所当然的事，是吧？当然，当然。A matter of course, 理所当然的事。Everybody loves their disputes to be resolved quickly as possible, as promptly as possible. It's a matter of course. Look here, the words in red. The agreement. Here it refers to the DSU. Emphasizes that prompt settlement means quick settlement is essential, fundamental, if the WTO is to function effectively. If the WTO is to function effectively, prompt settlement is essential, is necessary, is fundamental. The speed of the dispute settlement is important. Okay, good. Then there is one funny thing. One funny thing here. Here, flexible deadlines. What does deadline mean? Deadline. Yes, in Chinese it's called 截止日期. In English, it means when the deadline comes and you fails to finish, you are dead. Right? Deadline. Then, what does flexible deadlines mean? If it's a deadline, then it's a deadline. You must be died. Then it's flexible deadlines. What's the point of deadlines? Right? So there's something strange here. Flexible deadlines. When the deadline comes, if it's not dead because of the flexibility, then why bother setting a deadline? Why bother setting a deadline? Why bother doing something? 做某事还有什么意义呢？还麻烦做某事干什么呢？ Okay. Move on. under the previous GATT procedure. Rulings could only be adopted by consensus, meaning that a single objection could block the ruling. Now let's recall something. What's the predecessor of the WTO? Predecessor. What's the predecessor of the WTO? I mean, the organization before WTO is established, was established. The organization. Which organization? In 1994 or before the 1994, what's the organization? Yeah, good. You're right. There you go. It's called GATT. Since which year on? 2 years after World War II. Let's recall some other thing. You still remember who is leading the world order after World War II? Which country? Yes, good, America. And the United States governs the world by way of establishing international organizations. Which 3 types of international organizations are there? In the field of trade, which organization was established? In the field of trade, which one? Yeah, good. After World War II, in the field of trade, GATT was established. In the field of international finance, which organization was created? World Bank. In the field of international monetary matters, which organization? Exactly. IMF. At that time, I mean, in 1947, the predecessor of WTO was still called GATT. In Chinese, it's called 关贸总协定. GATT is not just an instrument, it's also an organization. 关贸总协定不仅是一个法律文件，还是一个国际组织。That's why we say GATT is the predecessor of WTO. Okay. Then, let's recall, continue to recall. Under the GATT system, there's also a dispute settlement system, right? And under this system, look, under the previous GATT procedure, look, rulings could only be adopted by consensus. What does consensus mean, or by consensus mean? In Chinese, it's called 共识 or 4 characters 协商一致 or 共识 okay, which means a ruling must be agreed by all the GATT members before it's binding. Do you think that's possible? Is it possible for us to have a binding ruling? Think about it. Again, I repeat it again. A ruling will have to be agreed by all the members, all the GATT members, before it's binding. A ruling in a dispute, a ruling was made. And this ruling will have to be agreed by all the GATT members before it gets binding. Which member will certainly block this ruling? Which one? The losing party, right? It's also a member. Okay? So, it's basically something impossible. Mission impossible. That's the GATT procedure. While in WTO dispute settlement, things have changed. The procedure has been completely changed. We adopt a principle of what? This is by consensus. Under the WTO dispute settlement, we adopt a principle of, you still remember, in the general theory course on international economic law, I told you the principle of which principle? In Chinese, it's called this. In English, it's called the principle of what consensus? The principle of a negative consensus, which means the ruling can become binding after only one of the members agree. Which means the ruling will certainly become binding. Which party will certainly agree with the ruling? Which one? The winning party, right? Which means under the GATT system, no rulings can be adopted. While under the WTO system, no rulings will be blocked. Is this part difficult? I don't think so. Because we mentioned this before. Okay, we mentioned this. Okay, let's go on. How many stages are involved in a WTO dispute settlement? Guess what we've learned in the course of general theory on international economic law. How many stages are there in total? How many? Three, okay. You translated yourself? Yes? Okay, good. How many stages are there in the WTO dispute settlement? 3. Let's recall. Stage 1, it's called what? There is a case. The first thing we need to do is what? Good. In English, it's called consultation. Yes, in Chinese it's called 磋商. That's right. And the English word is consultation. And the second stage is, what's the second stage? Good. Yes, good. In English it's called panel proceedings. And the third stage is what? Yes, it relates to appeals. But what's the name of the procedure? It's called, yeah, exactly. 上诉机构程序. How to say? Proceedings is the same. How to say 上诉机构? Not appeals. No, it's called this. AB proceedings. What does AB mean? Stands for? It stands for how to pronounce this word. Some Chinese people say appellate. Appellate. Strange, right? It should be pronounced as appellate. Appellate. Appellate body. Okay. You know, the third syllable from the last should be stressed. Again, I will repeat it again. The third syllable from the last should be stressed. The third syllable from last, this is the first syllable. The second from the last. From the last. The first one, the second one, the third one. Usually, the third syllable from the last should be stressed. But this is a special word. So it can never be read as appellate. It should be read as appellate. Usually, it's like that. But it's a special word. Okay. So there are 3 stages in a WTO dispute settlement. How long do we need before we go to the panel proceedings? To put it another way, how long can consultation last before we enter the next stage? How long? Good. Where is the answer? Is it here? No? How do you remember that? How did you get to know it? I just know it. Okay. Then 60 days. 60 days. Good, that's right. Almost 2 months, right? But it's 60 days in consultation. So my question is, if we are already in stage 2, panel proceedings, can the consultation continue? Yes or no? Look at the answer in red words. The red words, the words in red. Look. Even when the case has progressed. Progress means continue, proceed. Progress to other stages. Consultation and mediation are still always possible. So the answer is yes or no? Yes. Good. Okay, now let's come to this part about the approximate periods for each stage of a dispute settlement procedure. The target figures. Look at this sentence. In addition, the countries can settle their dispute themselves at any stage. Settle their dispute. What does settle mean? Good. Basically, there are two meanings for the word settle. Number one, just like what you said, to resolve something, right? To resolve, 解决. But more importantly, especially it will appear in the course of international commercial arbitration, it has another rather important meaning. It's called not resolve something. It's called, I'll explain it in English and you try to give it a word, okay? One is to resolve, the other is to end the dispute without going to a court of law. To end a dispute without going to a court of law. How do I say that? End a dispute means the dispute also has been resolved, but without going to a court of law. Just by the two parties. What does that mean? In Chinese, it's called end the dispute without going to a court of law. This resolved only by the two parties. So there will be something like settlement award. What does award mean in ICA? The final result is an award, yes? In the ICA, okay? 裁决. You will know it in the course of ICA, taught by Li Juan, I suppose, okay? Award. Then what does settlement award mean? It means the award is not rendered by the arbitrator or the arbitral tribunal. The dispute is resolved by settlement. Then the award is a settlement award, means the dispute has been resolved first by the two parties. Then the arbitral tribunal will endorse it. Endorse it. I will explain it in Chinese again. 当事双方先和解了，已经有个结果了，让这个仲裁庭再给这个结果背一下书，就叫做和解裁决。这个裁决不是由仲裁庭自己解决的， 这个争端不是仲裁庭通过做出裁决解决的，是当事双方自己和解的。但是最后，仲裁庭又给他背了一下书，做成了裁决的形式，叫 settlement award。Take a break of 5 minutes.